the petitioner or plaintiff appears by and through Ms. Lynn's called plaintiff's counsel. The defendant, Mr. Patel, appears self-represented. This is Bhagat, Manish and Sweeta Bhagat versus the N LLC Limited and Rajish Patel and Puja Rani. And Mr. Patel, a motion for entry of default judgment was filed on September 19th of 2025, scheduled for today. On Monday, you filed an answer, and I believe, I mean, it is out of time. I believe you have a request in here for the court to allow it out of time. And yeah, that's in the form of a motion in here, a separate motion. And then that you've alleged or filed an affirmative defense and or counterclaim. Now, this was just filed on Monday, Ms. Linscock. So I don't know if you've had a chance to go through all this.
I haven't spent a significant amount of time with it, Your Honor. I did go through in preparation for this hearing and try to pick out at least as it relates to the response to the motion for default judgment. So I'm certainly prepared to make argument on that if the court would like to entertain it.
Okay. So what is your response to his motion to file an answer out of time and motion for the court to deny default judgment?
Your Honor, plaintiff's response would be to request that the court not allow defendant to file an answer out of time or to even consider, well, first, in the first place, to file an answer out of time. We believe that, I understand that Mr. Patel cited excusable neglect as for why he otherwise was unable to file any responsive pleadings in this case. But at a high level, Your Honor, and the court may remember, Mr. Patel was present at the hearing for the TRO, in this case in June of this year. At that hearing, defendant was ordered to file an answer or responsive pleading, I believe by July 25th. Yep. The journal entry very specifically says that the answer deadline was July 25th at 2025 of this year. Mr. Patel and any other defendant in this case failed to do so. Now he appears to argue that he was unable to do so because he wasn't represented by counsel and that he was busy, specifically that he was busy working on things for the hotel. But I'd point out also that that same order enjoined him from having anything to do with the property itself throughout the pendency of the litigation. And I don't know that he was or taking any conduct on behalf of the property or to benefit the property. So I'm not sure what otherwise he may have been busy doing, to the point that it would be helpful for this court. We did look into and do some research on the viability of an excusable neglect claim by Mr. Patel. As I'm sure this court is aware, an excusable neglect claim or an extension for good, it requires the showing of good cause, Your Honor. And there's some helpful case law, specifically Tyler v. Cowan Construction, that says that it essentially stands for the proposition that neglectful indifference is not the same thing as excusable neglect. And the quote that I think is really powerful here is that the court writes, "Our entire judicial process for trial of civil controversies would be destroyed if a court summons or other processes were permitted to be treated with neglectful indifference. Mr. Patel had notice of this action. Mr. Patel and I communicated in advance of any of the court hearings. He's been in receipt. He's been served. He's been present. He heard this court's order. The second thing that I think is helpful is that in the Cox versus Community State Bank case, which I'm happy to provide all these sites to the court, that court held that default judgment cases specifically, which is what we have presently, excusable neglect exists when a party to the suit is not responsible for a failure to reply. In that case, the Kansas Court of Appeals very specifically indicated that it was not concerned with the fact that the litigant was pro se, and it cited that litigant's active involvement and knowledge of the litigation in finding no excusable neglect in that case. And then finally, an additional quote from another Kansas Court of Appeals case says that a pro se litigant cannot expect the trial judge or an attorney for the other party to advise him or her of the law or court rules, or to see that his or her case is properly presented. So in that case, confusion related to proceedings did not qualify as excusable neglect. They held that a party remains under a legal duty to take action to protect his or her interests as it relates to the litigation itself. And in this case, Your Honor, like I've previously stated, this isn't a case where Mr. Patel didn't know. This isn't a case where Mr. Patel didn't have notice. His explanation of excusable neglect reads more, from our perspective, like indifference. And I don't think that it meets the level of good cause required in order to sort of consider his answer out of time. And we would instead request that this court disregard his answer as untimely, dismiss or deny his motion to file an answer out of time, and proceed on our pending motion for default judgment.
Can you give me the site on that Cox case?
Yes, I can, Your Honor. The Cox case is, I've got 444 P3D 377. I'll put it in the chat as well.
444 P3D 377.
Yes, Your Honor. Can app 219.
What was the year on that?
2019, Your Honor.
Okay. Do you remember how long it was before the defendant filed his answer in that case? How much time had elapsed?
I don't know, but I'll take a look and see if we can pull it up. Quentin, who I'm not sure that you've met before, Judge. This is Quentin Aker. He's a new associate in my firm. He's got his laptop next to me, so I'm sure he can pull up that case and provide that to you.
Because I'm interested in knowing specifically what they said about balancing the fact that Kansas does not prefer default judgments, or they're not preferred generally, in light of, does it make a difference that it's after a year that somebody comes in and tries to file an answer out of time and it's post judgment, or is it, within the first few months of litigation or that kind of thing? But it does sound like both of those cases are on point with what's happened in this case. Let me address one other thing before I turn to you, Mr. Patel. Was Puja, Rani, was she personally served?
So because she too was out of the States, when we met on June 13th of this year, what the court ordered us to do was, we had done service by publication. So we had published service. We have an email address for her, so she's also been receiving the pleadings via email. We then served the entity itself through the Kansas Secretary of State as well. And then in the address that we have for her, she was also mailed the pleadings. And I will submit to this court that she too has attempted or been in contact with our firm in not a substantive way, in that I think we got a call or two after hours, and we're unable to connect otherwise. But I would submit that she has been, per Kansas statute, appropriately served through the publication mechanism.
Okay, so.
But to answer your question, because you can't do certified mail to Canada, we haven't gotten personal service through those means.
Well, I still think that I can grant default judgment against her and the corporation.
That's correct, Your Honor.
And that's what I should do, first of all, is grant your motion for default judgment as to, because Mr. Patel cannot represent the inn.
Correct, Your Honor.
As a non-attorney. Mr. Patel cannot represent another individual as a non-attorney. So his answer and his request pertain only to him individually, because he can only represent himself. So that's granted, and you may journalize that as part of the overall hearing or separately, with whichever you prefer. Now, Mr. Patel, I guess the only distinction that I would suggest with the Cox case is there the court was saying, we don't have a duty to tell you what the deadlines are. We don't have to tell you, have to look that up and figure it out yourself. In this case, though, I actually gave you a deadline to file that you disregarded. So that's a worst case scenario than me just saying, well, I expected you to figure it out and you're pro se and I'm going to treat you like as if you're an attorney and therefore I'm not going to let you answer out of time. I essentially was letting you answer out of time by giving you a deadline and you didn't meet that July 25th deadline. So tell me how, I'm looking at your motion, but in specific, because you have filed a
My wife has had the
combined
delivery.
opposition to plaintiff's motion for default and motion for leave to file out of time. And then you also filed she filed an affidavit and you filed a separate, I'm trying to find it here. I think you also filed a separate motion to extend and file out of time. There's your answer. This is the combined motion. This is your affidavit. Your attached documents. Maybe there isn't a, did you see a second separate motion just for filing out of time? Okay, I may have looked at the.
There is one.
The,
Hold on, Quentin's correcting me after let me look at, I'll pull the docket. I have the docket sheet up. Oh, it's all in the packet.
But tell me why you think there's excusable neglect here.
My wife was also like having baby, so like she was.
What? Can you talk louder? I'm sorry. And my air conditioner.
Like my wife was also in the hospital and like her due date was on August 12th, so she was having C-section and all, so she was not able to receive the motion also on time. she didn't like get the emails, and she didn't see any emails on time. Like she was having the delivery on August 12th.
Who was?
My wife, like Puja Rani.
The co-defendant is his wife, Your Honor.
Right. And she was having a baby. Okay, well, maybe in Canada, that's excusable neglect since they give 6 months of maternity leave or something,
Like she
something
had,
wonderful, maybe even 2 years, I heard from somebody one time, but it's not a legal,
she was
base.
having C-section that time, that's why. She
Well,
had
as far as she's
C-section.
concerned, you can't represent her anyway.
Yeah.
And I'm gonna look at your affidavit here.
Your Honor, while you're looking, I'm not good at doing two things at once. So if you want me to be quiet while you're perusing, just tell me. But in the Cox motion, in response to your earlier question, or in the Cox case, that default judgment motion was granted 30 days after, I'm sorry. Oh, that was a summary judgment case. Okay, summary judgment was granted 30 days after there was no response. 2 weeks later, they tried to get in that case, the defendant tried to get more time to respond. But the court says in that case that the same rules would apply for default judgment. So there's not a significant amount of time lapsed in that case to this court's point about how long when we're balancing the needs of the parties to have issues heard on the merits versus finality of the case itself.
Yeah, I suppose the difference is when you do a motion for summary judgment or motion for judgment on the pleadings, then the judge is making some factual findings.
Yeah.
Because there are allegations, factual allegations that are not denied because there's no response to the summary judgment pleading. And on a judgment on the pleadings, it presumes that the courts looked at the allegations and found the pleadings themselves to be sufficient to grant a judgment.
I think what's helpful in that case is that the Cox court said, specifically in default judgment cases, that excusable neglect exists when a party to the suit is not responsible for a failure to reply to the petition or counterclaim. And in this case, I don't believe that Mr. Patel has made any good cause showing that he's not responsible for the failure. And when Kansas law in general, when we were looking at when good cause exists or excusable neglect exists, most of those cases are when the Court of Appeals has found excusable neglect is when the defendant was completely unaware of the case when default judgment was granted, or there was an issue with the actual impact of service to the extent that the other side, didn't have knowledge or awareness. And I think in this case, again, Mr. Patel has been a participant in this litigation itself and just declined to file a responsive pleading at the deadline. And I would also note the deadline for him to file his answer was July 25th, 2025. We didn't file our motion for default judgment until September 19th. So even if he had filed a motion for out of time, even based on a delay that he was experiencing, there was additional time built in between when his answer was due and when we filed our motion for default judgment. And so I think that is stronger argument in favor of why the default judgment should be granted in this case, and that his motion should be denied.
Okay. I always struggle with these default when I actually have an appearance or previously had an appearance and continue to have appearance by a party, but yet there's no answer because, you know, they're trying to participate. It's just legally the documents that need to be filed aren't filed. Well, I'm gonna look at the paragraph that he actually asserted on, these aren't page numbered. 1, 2, 3, 4, 5. On page 5, it is paragraph Roman numeral 4. He states that defendant resides in Canada and is not familiar with Kansas civil procedure. He believed the matter could be resolved because the parties had agreed to amend balloon payments. He also was preoccupied with emergency septic system repairs and lacked Kansas counsel at the time. Defendant acted in good faith, maintaining employees and surveillance at the property. The delay was modest and caused no prejudice. These circumstances fall squarely within the definition of excusable neglect. And then paragraph 5 is that plaintiffs face no prejudice. They are already protected by the TRO. The case remains in early stages. By contrast, default would unjustly deprive defendant of $77,000 loss of business and investments. So the fact that you're not aware of civil procedure as a pro se defendant is not excusable neglect. You're presumed to know when you're doing business in this state and you have a corporation that you're part of that is doing business, to know the law in the state, and to realize that as a business, you might be sued or a claim may be made against you, and not that you have to have an attorney on retainer, but I think that's part of the acceptance of engaging in business practices, is that you have no provision where the suit has to be brought in Canada or somewhere else. The activities in Kansas, suits brought in Kansas. And not only, even if you didn't know, I ordered you to comply, and I would have accepted your answer even if it was out of time. And I probably would have considered it, if you had filed it before the motion.
Yeah, this is just
Or you
struggling.
filed it shortly after the motion, but here we are the week of court, and you're filing lengthy responses that are not timely based on what you believe to be the merits of your case. So, it's not fair that I wouldn't excuse an attorney for failing to meet such a deadline. And it's not fair because you're pro se that the other side who hires an attorney has to be disfavored because I'm working so hard in trying to accommodate someone who's self-represented, who conducts a business in the state of Kansas. So I don't see it. However, just for the record, since default judgments aren't ordinarily preferred, and that's usually when good service isn't procured or there's some reason for it, more than good cause, really excusable neglect. And like you said, indifference is not excusable neglect. But I do want you to respond to his allegation that because you received the TRO, because there really hasn't been any prejudice to your client, that the court allowing this answer now out of time, and you add the fact that you're not just answering, you're trying to assert a counterclaim, which increases their need for litigation beyond what their petition addressed, is another issue. But besides that, what is your position on his argument that your client will suffer no prejudice if the court allows his answer out of time and denies your request for default judgment?
Yes, Your Honor. I would respond to that first of all, our clients have been and would be prejudiced and suffer prejudice if the request to file an answer out of time was granted in a number of ways. First, when we talked about the Tyler v. Cowan construction case, that court did say that there certainly is a balance between the effect of granting additional time because we prefer cases to be resolved on their merits. But there is also highlighted in that case that the other side of the balancing test is the necessity of achieving finality in litigation. And this case was filed in, April 14th of this year. And this is the first attempt that this individual who's participated and spoken with counsel to otherwise engage in this. And the prejudice is that by allowing him to now come in at this late hour, after my client has incurred significant expense to repossess the property, significant expense to get the TRO, significant expense to make sure that we were getting service in all of the appropriate ways, expense in drafting the motion and then paying for us to be here. And then for the results of that to be that Mr. Patel, who is not obligated or required to follow any of the rules, can come in and say, well, actually, I needed more time, and actually, I would like to sue you all as well. The prejudice would be ongoing in that there is no mechanism in which he would be obligated to follow any sort of scheduling order or response deadlines or discovery deadlines, or any way to ensure that he intends to engage in that practice at all. And I think what is one of the other things that is most important to remember is that as the court indicated, the prejudice is that parties and litigants are entitled to finality. The rules of civil procedure exist so that the parties who are navigating through the system itself have an opportunity to know what they're supposed to do and follow it. And I understand that Mr. Patel is not a lawyer, but to the court's point, my client did all of the things that he otherwise was supposed to do to relieve himself of the issues that were being caused by this particular incident. He hired a lawyer, he followed the processes, he followed the procedure. He has been in possession and fixing up and trying to keep the property from being in complete disrepair during the interim while Mr. Patel has not engaged in any of those acts at all. And then now allowing Mr. Patel to come in at the last hour does significantly prejudice both all of that work and a client or an individual who engage in the system the right way. And to this court's point, it creates prejudice to the BATs in that they followed all the rules and everything that they were supposed to do and incurred costs in doing so, and otherwise are entitled to the finality of litigation and the finality of this case so that they can have what they need to move on and move forward with the property itself. The temporary restraining order does effectively give them possession, but in a review, at a high level review of Mr. Patel's answer, it's difficult for me to tell what specifically, he takes issue with that. And I think at this point, he shouldn't be allowed to have these individuals go through the cost, expense, and effort of getting us to this point, and then otherwise say, well, I was busy, but I'm here now. I think that is prejudicial to my client, Your Honor.
Okay. What about making sure, he does make some statements about modifying balloon payments or something like that. He can't really make arguments on appeal of things that he didn't argue to the district court. But what if his suggestion to the court is that he was misled by you, particularly into believing that this matter could be resolved outside of court in lieu of him filing an answer?
I would submit to this court that I have not spoken with Mr. Patel related to his answer or his answer deadline since the June 13th, 2025 hearing. There has been no conversation
Okay.
between myself or my firm with him related to any sort of settlement. I know I don't want to represent to this court. I think him and his wife both made calls into the law firm, but I would represent to you that no one here, and especially not myself, would have otherwise indicated to him that we could reach some kind of settlement agreement in lieu or granted some sort of implied extension. That certainly did not occur.
Okay, well, I believe you. The fact that you don't have any correspondence or any ongoing efforts to negotiate with him or renegotiate or settle makes a difference, because you're an officer of the court. But, you know, I don't like on mortgage foreclosures, when I find out they're trying to get money and work a whole nother plan, and then it falls apart, and, you know, the homeowner is relying on the representations, believing that they're gonna rework out a contract or rework out a deal, and then they don't.
Right.
So I just want to make sure the record's clear on that. And if there was no back and forth communication about any potential alternative disposition of this case, then he had nothing to no reason to believe that he was going to be able to get back into the property and rework a contract and regain his position or equity over, or not equity, but
Yeah.
possession
And I
of
will,
property.
sorry, Judge, I didn't mean to speak over you. Prior to the TRO being granted, Mr. Patel and I had engaged in email correspondence. Sometimes I would be copied on correspondence with who I think he might have been trying to engage other counsel. But our last discussion was May 16th, 2025. And my only representation to him is I can do nothing, and we can agree to nothing until I also have contact with the other party, because at this point in time, I had not had any sort of communication with his co-defendant. And I was trying to communicate to him, I need a way to make sure that if we're going to have conversations, we need to have them globally. And at that point in time, any sort of discussion related to settlement or that there may be an option for him to regain access or anything like that ceased. And so that is sort of redundant to what I said before, but I just wanted to make the record clear. We did have early conversation about how we may be able to avoid the litigation, the TRO and all of those things, but they didn't go anywhere.
Okay, well, I think once we went to hearing on the TRO and I granted it, it was clear what your client's intentions were and should have been clear to him. And when I said to him, you need to get an answer on file, this is litigation. If you're gonna present a defense or make a claim, then you've got to get that done. I think all of the conveyances to him were clear that this was litigation, that he had time deadlines, and there were critical things that he needed to do. And if you never reached out to him in between that time, then there was no reason for him to believe that there was any alternative road for him other than doing what the court had instructed him to do. And it's not a aha, I got you moment, because I did try to work with Mr. Patel on what I thought was reasonable and would not necessarily be detrimental and would fulfill the spirit of Meredith's, litigation as opposed to, or litigation on its merits as opposed to a default judgment. And then last but not least, when I granted the TRO, and you can correct me if I'm wrong, I heard some evidence, reviewed some documents. In the court, usually on TROs has to find that the court believes that the party seeking it will in all likelihood prevail. So I've already made that finding. We have had some hearing and decisions on the merits of this case, but I do not agree just because you have a TRO in hand that your client is confident that he has been, that there's been adequate action for him to resume as an owner. For instance, if he wants to go get a loan, a business loan, and the banks find out that he has this litigation, they're not going to loan him any money. So there are things, Mr. Patel, that are detrimental to the plaintiff just because this pending lawsuit is happening. In fact, sometimes people can't even sell their own personal homes when they have a lawsuit on file against them, even in the absence of, there's not even a judgment. Certainly that's true generally with federal litigation, but you would have the same inquisition and have to respond to a lender about the litigation. And so I think he's entitled to restoration of the property as I ordered in the TRO. I don't think anything's changed since then. And I don't find that your lack of participation in the litigation and filing an answer on time, and especially with this counterclaim and other things, that the court should allow the litigation to proceed when it is, I think, ripe for a granting of default judgment. And I'm not going to accept your motion to file an answer out of time. I'm denying that request and I'm granting default judgment against you as well. Now, there are things that you can file, pleadings, when there are summary judgments in the district court, and then there are deadlines, which you have a 30-day appeal notice. So you can appeal to the Court of Appeals, but you need to preserve that by filing a notice of appeal. And then a higher court in Topeka will look at all the transcript information and the hearings and all the pleadings and whatever's provided to them, and determine whether or not the arguments that Ms. Lindskog made are correct and that my ruling is legally correct. And cases of 50% of the time are probably, I hope that's not my record at this point, 50%, but cases are frequently reversed and remanded to district courts across the state. And so that's your way to further make your arguments and have an independent body review those arguments based on the record that and the rulings that I've made today. Okay?
Your Honor,
Yes.
I would request that the court order a bond should Mr. Patel elect to appeal the court's ruling today. to get to enter a supersedis bond for at the very least the amount of the damages that are being that we've prayed for, to the extent that would at least preserve if Mr. Patel is going to file an appeal and sort of delay all of this even further. The bond itself would act to at least protect my client from additional risk or prejudice as it relates to anything else that may go on in the background as it relates to assets that maybe we may be able to garnish or anything like that.
How much are you requesting?
We prayed for $77,686. There's a typo because I've got multiple cents here, but $77,686.33, Your Honor.
Well, I am going to set an appeal bond in the amount of 25,000. But once he can file an appeal, he doesn't have to pay that money at the time he files his notice of appeal. But when he dockets the case or shortly thereafter, when the case is docketed, he can file a request with the Court of Appeals to modify that. So that can be set, that's not set in stone. That's what I'm setting today. I think it would behoove you, Mr. Patel, to talk to an attorney about the appeal process and perhaps get some assistance. And there can be requests for the court to waive any kind of appeal bond. As I said, I can set whatever appeal bond I want, but the Court of Appeals has a right to set that aside and review the bond as well as the case decisions themselves. So, but I do think, again, just writing up a notice of appeal, putting it in the file, but yet, like I have a case that's 6 months old because a defendant in prison filed a notice of appeal. He's self-represented. He's not entitled to appointment of counsel on a malpractice case, on a civil case, but he's not docketed the appeal, and the Court of Appeals doesn't recognize the case until it's docketed. So I don't know who's going to dismiss the case or when exactly, procedurally speaking, but I don't want, I want you to have some good faith brought forward as to the legal challenges that you're making and the appeal process that you're ready to do, and that you are willing to place money on it, rather than it just being a piece of paper that's filed that then keeps the litigation outstanding. So, and you just have to you have to follow the appellate rules of the Supreme Court. That's all. That's really all I'm saying. But I'm not going to set it for the full amount, but I am going to set it for an amount that I think requires an investment in a belief in the merits of the claim itself, and that I think would cause a reasonable person to evaluate the situation rather than just especially filing a pro se notice of appeal that may not result in correct docketing and understanding of the appellate process. Not trying to restrict his ability to appeal. I would never do something to cause a situation and create a situation that I'm undermining someone's right to appeal. But I do think overall in this case, such a request and ruling by the court is appropriate. Okay. All right. Yeah. And you will journalize everything?
Yes, Your Honor.
All right. If there's nothing further today, we are